Grade A-. He properly sequenced the investigation. Sworn LP statement. First subject interview. Second. His approach to a cooperative, distressed, first-time arrestee was measured and professional throughout. He adjusted her handcuffs when she reported claustrophobia, offered medical evaluation without hesitation, and exited through the rear of the store to protect her from public exposure. That reflects procedural justice in practice. The deduction is the Miranda warning. 4 components required, 1 delivered. That single procedural failure built the suppression issue, now sitting at the center of the prosecution's case. Juliana Rivero, grade C+. She had already confessed to loss prevention before police arrived, which limited her options. But she had the right to remain silent with law enforcement, and never invoked it. She provided detailed itemization, specific time frames, and her exact method, without counsel present, without being asked to elaborate. Cooperation carries sentencing value. Silence also has value, and she exercised neither in the right sequence. Loss Prevention Associate Yomaira, grade B+. Dedicated surveillance UPC verification, clean, sworn statement to law enforcement, 18 years of experience. The concern is the substantive in-house interview conducted before police arrived. That interview is admissible, but it creates civil exposure, false imprisonment claims, coercive interrogation allegations. For felony-level conduct, the cleaner protocol is to call law enforcement first and hold questions until they arrive. Neiman Marcus Loss Prevention, grade A-. Solid protocol across the board behavioral surveillance, documentation, correct escalation to law enforcement for a felony matter. The pre-police interview is the single caveat. Lessons from this case. A Miranda warning is not a formality. All 4 components in sequence before the first substantive question. One missing element can hollow out a detailed confession that was freely given. Officer Fong did nearly everything right in this contact. The Miranda failure is the exception, but it may be the exception that determines whether the prosecution's felony case holds together. The private actor exception is real and underappreciated. Loss prevention. Employers' private investigators. None of them are bound by Miranda. What you tell them before police arrive is admissible, full stop. Speaking to police without counsel present is almost always a legal mistake, even when the facts are not in dispute. A lawyer in the room before you speak costs far less than an unprompted, detailed confession without one. For loss prevention, an in-house interview before law enforcement arrives may be admissible, but it carries civil liability risk. When the conduct is felony level, call police first. The admissibility you protect by waiting is worth more. On Fourth Amendment sequencing, this bag search survived because the arrest was formally announced before the search began. A search conducted before that announcement operates under a different standard. The sequence determines admissibility. The overlap between admissible LP statements and potentially suppressible police interview statements creates a 2-track evidentiary problem the prosecution will need to navigate carefully at trial or plea. Intent evidence is the other variable. Florida's organized scheme statute requires ongoing fraudulent intent, not just repeated theft. The defense will argue the distinction. The prosecution will argue the pattern speaks for itself. Juliana faces up to 5 years per count on 2 third-degree felonies under Florida Statute 775.082. Whether either charge survives a suppression motion will drive the actual outcome. No court records were located at the time of this analysis. The case status remains unknown. Based on the Miranda issue and the LP confession distinction, this one is likely resolved at the plea stage. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and do not forget to check out our channel for more police interaction and courtroom content.